Good morning, everybody. It's amazing, we do these once a quarter. I can't believe another quarter is already come and gone. But here we are in the spring. So happy Saturday. This is a project, if you will, an ongoing project of the Golden State Manufactured Homeowners Education Fund. For those of you who may not know, the Education Fund, or the Ed Fund, as we call it, is a sister corporation to GSMOL. GSMOL was founded about 55 years ago. The Ed Fund has been in existence for just over a decade and has been very active for probably only about 7 or 8 years. But as the name indicates, the key component, the key task or goal of the Ed Fund is education. So that's why we're all here today. And I have to tell you that you're not the only ones who get educated by these. So do I. As the questions come in and I research them or think about them, there's always education that I'm gaining as well. So we always appreciate your participation. And we are here to empower you, to give you knowledge about your rights, because without knowledge, you don't know your rights. And if you don't know your rights, you can't enforce your rights. So that's always been a core goal of GSMOL, and it's really the primary goal of the Ed Fund. The Ed Fund is a 501c3 nonprofit, unlike GSMOL, which is a 501c4 corporation under the Internal Revenue Code. If you donate money to GSMOL, you can't write that off on your taxes. But if you donate to the Ed Fund, you can write it off. It's a tax-deductible donation. If you like what you're hearing today and you're able to donate, we always appreciate that. We do have grant money that the Ed Fund has been lucky enough to obtain the last couple of years, which immeasurably helps us to do a lot of the things that we want to do statewide to help individual homeowners or groups of homeowners. But if you see it within your ability to donate anything, rest assured that you can write it off if you donate to the Ed Fund. And you could go to the website to learn about that. So today, I also wanted to briefly introduce myself, because not everybody really knows who I am. I've been an attorney since 1982, and I've been specializing in mobile home law since 1986. I've only represented homeowners and a few mobile home dealers. Currently, I also represent some resident-owned parks. I've never represented park owners. I actually lived in a mobile home when I was in high school in Morgan Hill, California. My father was a GSMOL president for probably at least a year. Back in those days, the civil code was probably about 2 or 3 sheets of paper front and back in the 1970s. Now, of course, it's a very thick book, and most all of the laws that we call the mobile home residency law are there because of the efforts of GSMOL over the decades. The leaders, the volunteers, the lobbyists who have worked very tirelessly to, protect your rights and put a body of law together that's a very specific consumer protection law. So that's just a little bit about me, and I've represented GSMOL back during the 1990s and have been representing them again since 2009. And in between that, I represented another local homeowners organization in the San Francisco, San Jose Bay Area. I've been involved with the Ed Fund since its creation, and I'm on the board of directors along with a few other folks on the call today, like Ann and Mary Jo and Martha. So thank you all for joining, and this is going to be our agenda today. I'm going to begin by very briefly summarizing the current bills that we have in front of the legislature. There'll be more coming about those bills as we get deeper into the legislative year, but I wanted to make sure that I spoke about them at least briefly. I was then asked to address the topic of home resales and inheritance rights, the issues involving allegations of park interference with folks selling their homes, the rights of heirs when the homeowner is deceased, and a little bit of crossover there in terms of what happens to a home after an eviction occurs. We've had eviction moratoriums for most of the last 2 years because of COVID-19, but a lot of that's been being released now. So there's going to be a lot more interest in that topic. I also have received 15 pre-submitted written questions that I'm going to address and provide a response to. And then the second half of today is going to be all about your questions, which you can ask according to how Ann just introduced that. And we want to try to see if we can answer everybody's question today, if possible. I'll have a little bit more to say about the questions from you all when we get to that point, just to remind us how to do that. So first of all, let's look at our legislative session, the GSMOL legislative agenda for 2022. As most of you know, every year GSMOL donates a lot of energy to focusing upon any areas of our mobile home residency law that are vague or ambiguous, or maybe there's a problem that's cropped up with the current language where we see how residents are not well protected or maybe being taken advantage of. And as with every year, we have some key bills that are now working their way through the legislative process. The first one of those is SB 869. And this is a bill that's going to require that park management be trained and licensed. This is a topic that I know for probably almost everybody on this call, there's always been consternation about, why don't managers know the law? Why don't they follow the law? And how are managers even chosen? What sort of qualifications do they have? Because as we know, although not all park owners seem to know this, managing in a mobile home park is far different from managing an apartment complex or a condominium complex. Very different sets of laws, very different assumptions and realities about our industry and our way of living. So SB 869, if passed, will require that a certain amount of training, certain number of hours of training that Department of Housing and Community Development, HCD, would be supplying the program, that resident managers would first have to be qualified before they could be hired. And then there would be ongoing training, what we would call continuing education, much like I have to do every 3 years as a lawyer in order to keep my license to practice law. So we're in discussion right now about how many hours that might look like and some of the specifics and details. Obviously, there's opposition to the bill, as no surprise. But the fact is that only some park owners bother to train their managers before they're hired. And this bill would aim to fix that problem by requiring every park to train its management personnel. The second bill I wanted to mention was SB 940. This also fixes what has become a glaring problem in the mobile home residency law. And this pertains to the exemption from local rent control for new construction. Back in 1989, language was inserted into the MRL that took effect on January 1st of 1990, which said any spaces built after that date, after January 1st of 1990, would be exempt from local rent stabilization or local rent control. And the idea was that we want to stimulate the construction of new parks or new spaces. And without that exemption, no new parks would ever be built, right? Was the argument, because who wants to build a park if they know they're immediately going to be subject to rent regulation? They have all these costs of construction, they need to recoup, and they're just not going to be incentivized to create new parks. Well, what we have found out in the decades since, 32 years have gone by, we still have this archaic out-of-date new construction exemption, where a park built in 1991, for example, is still considered new construction, which would be a complete misnomer. But what we found out is only 1.5% of the parks in California have been built since 1990. And since the year 2000, only 14 new parks have been built in California, and no new parks have been built since 2013. So this exemption really has not at all served the purpose for which it was intended. There are other issues other than local rent regulations that have prohibited or retarded maybe the building of new parks, and that has to do with local land regulations, land use regulations, politics, all sorts of other things. So this bill is going to solve the problem. The bill is intended to solve the problem of this outdated new construction exemption by saying that if a new park is built, if an entire new park is built, then it's exempt for 10 years. There's a rolling 10-year exemption for a new park so that they can recoup construction costs without being regulated. For new spaces, for example, you have a lot of parks where the park's been around for 50 years, but they added 10 new spaces to one part of the park. Well, those spaces will no longer be exempt as soon as the existing rental agreements for those spaces expire or are renewed. Because we don't want this unequal situation that we have in a lot of parks where you have 200 spaces and only 10 of them are exempt from rent regulation. And it's just not fair to those people to have to compete in terms of paying rents or getting their homes sold with the other 190 spaces that are covered by rent regulation. There just is no good purpose for that. In our view, the cost to construct a space is nowhere near the cost to build an entirely new park. Sure, you have a grading cost and you have to hook up utilities, but park owners shouldn't, although they're trying to certainly argue right now in our legislative process that no new spaces are ever going to be built now if this bill passes. It kind of reminds me of what we heard when we got our tree driveway bill passed back in the year 2000. If this bill passes, the park owner is going to take every single tree out of all their parks because they don't want to have any liability to maintain them. Well, that didn't happen, of course. They might have removed a few of them, but nobody's going to do that. So we're hopeful that we can get this new construction exemption updated, if you will, and that within a park, we're not going to have any more situations very soon where some spaces are exempt and some are not within the same park. The third major bill is one that Martha O'Connell, actually, who's our co-moderator today, has strongly advocated for, and that concerns clarifying and broadening the rights of you, the homeowners, to request meetings with management. They're currently under 798.53 of your mobile home residency law. There currently is a requirement that if residents request a meeting on certain issues, management has to meet with you. And the idea is, look, let's try to sit down and work these things out. If y'all have questions about a rule or a regulation or policy or conduct within the park by other residents or management, it's much better to sit down and discuss it and before calling me or bringing lawyers into it or anything else. What we found, though, is that in some cases, management's reading this section very literally and saying, well, it says here that we meet and consult with the homeowners or with a representative. We'll do either, but we won't do both. So we either meet with the residents without, a GSMOL person, for example, present, or we don't meet with the residents at all. We only meet with your GSMOL representative. I mean, that's just unfair. That's not what the bill originally in the language of this section ever intended. So we're broadening that to include meetings where the homeowners and the representatives can participate. It could be telephonic, it could be in person. The items that that we're meeting about now are broadened to include a few other issues that have really become important since this bill was initially enacted, such as utility billing and utility charges, park improvements, common area facilities and availability. And if the park owner can offer Zoom technology like we have here, not all parks can in some areas of the state, but if you have the internet power and you can offer it, then the meeting could also occur this way. It could occur virtually. So that's Assembly Bill 2031. So those are our three main bills. We're also monitoring a fourth bill pretty closely, which is AB Assembly Bill 2002. We have no position on this bill currently, but we're carefully monitoring it. This is a bill that WMA, the park owner organization, has sponsored. And what it says is if a resident in a park has a code violation that Department of Housing has cited and they don't fix it, that the park owner cannot lose its permit to operate unless the park owner owns the home. So the bill is saying if there's a home owned by a homeowner, not the park owner, and there's some kind of code violation and the homeowner either won't fix it or can't fix it, right now the law says that HCD can pull the permit to operate. This is going to say that they don't lose, the park doesn't lose the permit to operate unless it's a clear health and safety issue. So it's an interesting bill. We're basically monitoring that. So just stay in touch as the session continues with those bills, which I think all are very, very important. And again, every year we're looking at the MRL to try to discern, where we've got gaps, where we've got black holes or spots that need to be kind of filled in and attended to. And these bills, many times, are the result of the kinds of issues or complaints that you all bring to GSMOL and say, hey, what about this problem? I'm having this problem here. And then maybe it hasn't even been thought about, or we haven't realized, wow, the MRL doesn't really cover that. So it's always dependent upon you all in your day-to-day living and struggles within your own parks to apprise us of what these problems might be to be addressed. So I wanted to, Anne suggested, based upon the number of communications we get about these issues, I wanted to take just a few minutes here to talk about park interference with home sales or the rights of heirs, because there is a lot of confusion about that. And I think because of things beginning to really loosen up now, a lot more people might be thinking about selling their homes. Inheritance issues are always present. So we want to make sure that folks understand what the rights of heirs are. There's basically three sections of the mobile home residency law that are very important to look at when we're looking at these issues. And they all actually come back to back. And that's 798.73, which governs the removal of mobile homes on resale. 798.73.5, the very next section, which governs upgrades and repairs on resale. And 798.74, the very next section again, which governs management approval of buyers. Those three sections together form a very important part of the mobile home residency law. The first section, point 73, was actually called the Mobile Home Resale Eviction Protection Bill when it was put through the legislature back in the 1980s. I actually pulled the history of this section, and it was back when Governor Jerry Brown had dark hair so long ago that this passed. But it's a very important provision because prior to this section, the way it reads now, there was this thing in it called the 17-year rule, which said if a mobile home is more than 17 years old, the park can require it be removed when it's sold. This bill that created our current language changed all of that by saying the only way that a park can require a home to be removed from the park when it's sold is if it's substantially run down or in disrepair or has code violations that can't be fixed, essentially. And it's very important to note that the park owner has the burden of proving this. So we have these situations that result, and I actually had to take a case to trial about 15 years ago up in the gold country, where the park owner suddenly told this elderly couple who wanted to sell their home and relocate to Los Angeles area to be closer to their kids because they're in their 80s and they wanted to have family closer because of all their healthcare needs and so forth. And the park owner simply said, your home was manufactured in 1971. It's too old. I'm not going to let you sell it in the park. It's a fire trap. And he just kind of made this broad, bold pronouncement that came only because he happened to be watching the news one night and saw a fire in a mobile home park and thought, oh my gosh, I better not let any of the older homes in my park get sold in here. Well, thankfully, this code section gave those particular clients of mine rights. And even though the park owner wouldn't agree, and we had to go to trial and win the trial, this section typically protects people without having to get to court, because it says, again, the park owner has the burden of proving substantially run down or in disrepair. So the first thing to know about mobile home resale is if you all or somebody you know is saying they want to sell their home and they give the initial notice to the park, a 60-day notice that says, I'm intending to sell my home. Many parks have a form for that. That's the first step. Then if the park comes back and says, we're not going to let you sell your home in place because it's too old, it's too run down. Well, they have the burden of proving that, as I said, and that is going to require inspections. It's going to require something more than just the park looking at the house and going, I just think it's too old. In my experience, very, very, very few homes would ever be deemed substantially run down or in disrepair. And if there are code violations, typically they can always be fixed. Sometimes they can't. Sometimes if a 50 or 60-year-old home has aluminum wiring and it's fallen all apart, it may be beyond fixing. But my experience is almost every home can be brought up to code or repaired if it needs to be. And that leads us to the second section, 798.73.5. This is a section that governs resale upgrades or repairs. When you're selling your home, you give your notice of intent to sell, and you should in that notice or have your agent, your dealer salesperson or your broker sales agent, also in that notice, ask the park, please give us a list of any written repairs or upgrades that you're going to require for us to sell the home. This section says they have to give that list within 10 business days of the request being received. And this section is very important because it limits the jurisdiction of the park, if you will, over where these repairs or upgrades could be required. They have no jurisdiction to the inside or in connection with the inside of your home. They can't require that the dishwasher be repaired or that flooring be replaced. Now, the buyer might require that, but the park owner can't. The park owner's jurisdiction under this section is limited to the outside of the home, the exterior. And it's also limited to code violations or violations of rules and regulations. Many times, and I've been involved in more situations like this than I can count, many times when the park list comes back, it could be lengthy. I've seen some lists with 25 or more items. The kinds of things that the park has legitimate ability to require would be taking the grease off the driveway, fixing a mailbox, painting a mailbox, tightening handrails, fixing dilapidated steps that are a trip hazard, replacing the carpeting on the steps, replacing dented awnings in the carport that have been hit, by cars going in and out, landscaping that needs to be attended to. But again, they can't say put a new roof on your house or replace all the bathroom flooring. That's beyond their jurisdiction. There are significant disputes that can arise in these situations. Sometimes the worst or the most the biggest kind of problem areas would be if the park says, we've discovered that your home is too close to the lot line. You need a 3-foot setback. It's only 2 feet 6 inches. You have to move the house 6 inches. Well, even moving a home 6 inches could require huge expense. And in those kind of cases, sometimes we have to get Department of Housing involved. We have to say, okay, we'll get HCD out here to determine, is this actually a violation? Because they could still allow structures to be within 3 feet of a lot line if there's, fire treated and safe construction that doesn't allow for flame spread. So sometimes some significant fights can occur about that. Another common one is, the whole house has to be repainted in order to be sold. Well, we have to look at the house and say, is that true? Is the paint really chipping off and fading off? Does it just look terrible? Maybe it does need to be repainted, but not always. Maybe the trim just needs to be upgraded. A lot of repairs can be made to just specific areas of the house without significant cost. There are, again, some areas, though, that are very legitimate. Water heater situation has to be properly strapped. It has to be properly secured within the cabinet. The steps that I mentioned, that's a real common area where steps are falling apart or they're not constructed according to code. Some of you may or may not know that. If you go on the Department of Housing website, they have a diagram for how steps are to be constructed, right down to the very exact specifications of the width of the risers and everything else. So that is the upgrade section. Parks can try to block a sale by saying the house has to be removed from the park. We talked about that one in the first section. They could try to interfere with the sale by requiring large lists of upgrades, some of which they have no ability to require. So we just talked about that. The third section is the very important section, 798-74, that deals with the approval of your buyer. I don't know how often we hear that someone's trying to sell their home and multiple buyers have been found, and those buyers make applications to management and they're always turned down, one after another. Well, we can't get management to accept any buyers. What's going on? Well, 798.74, a very important section that was actually updated and strengthened only a couple of years ago, provides that there's only 2 grounds for a park owner to deny an applicant. Number 1, financial ability to pay rent, meaning if the resident, the prospective resident, does not make enough money to pay the rent, doesn't have the financial ability, they could be turned down. The second ground is if, based upon past tenancies, this person or these persons are deemed by their previous conduct to be likely not to comply with the rules or regulations of the park. That would be somebody who has evictions on their record because they didn't follow the rules in prior, home tenancy situations. In my experience, that number 2 ground is probably used about 0.001% of the time. When there's a denial. Almost every time the denial is based upon financial ability to pay rent. There's 2 components to that. Number 1, income. How much income do they make? And number 2, credit rating, credit score. What you want to know, if possible, is whether the park has written policies about this. Some parks do. The better park owners who operate more effectively, I think, and responsibly, they're going to have a written handout that they give to the sales agents, the dealers and brokers and agents. and salespersons that says, this is exactly how we proceed when we get an application. In most parts of the state, and almost every part of the state, the income issue is defined as a ratio. Usually parks will want 3 times income over housing related expenses. That would mean if the park rent and utilities are $1,000 a month, they would want the buyer to show monthly income of $3,000 per month. It's not a hard and fast rule. It's not in the code anywhere, but it seems to be a policy that has been adopted in most areas of California. I've seen a few parks that want 4 times the income, which I think is probably not reasonable. I've seen some parks who want to use net income as opposed to gross income, and I also think that's probably unreasonable. The vast majority of parks use the gross income and the 3-to-1 ratio. So, your buyer needs to have sufficient income. How's that shown? Pay stubs, W-2s, 1099s, some kind of evidence. We also got the section strengthened a few years ago by requiring that if the homeowner has other assets and they want to disclose those assets in the application, the park has to consider them. That would include things like savings accounts, stocks and bonds, other real estate that they own that's getting income, rental income, any other kind of assets, trust income that they're getting. And it just makes sense that those are also assets that ought to be considered if the prospective resident wants to disclose those assets. So that's 798.74. And once a complete application is submitted with all the information the park requires, the park has 15 business days to process the application and make a decision. If they decline the prospective buyer, they must state that in writing to both the buyer and the seller, and that written letter or notice also has to describe the grounds upon which the denial was based. In other words, the income couldn't be substantiated. Part of the income was bonus pay or overtime that maybe is not guaranteed. Or, the credit report had problems. You have late pays, the score's too low. Maybe the person has, a district attorney garnish of child support or something going on. They have to state those reasons. A lot of battles happen over that, as you could well imagine. And I've had a lot of files where what we've done is met with both the parties, gotten more information, clarified information, and then resubmitted everything to management to say, we're going to ask that you take another look at this. Once management knows that you're really earnestly proceeding with this and maybe challenging the initial denial, sometimes that can turn around. And oftentimes with a lawyer involved, they can turn around because they know we can't just, flippantly deny this anymore without possibly risking we could be sued if this transaction falls apart and the selling homeowner loses their buyer. The park could be liable for the lost sale. And that could be a significant liability that they don't want to risk. So those are all important sections that together give great protection in the case of mobile home resale. The other section I just wanted to look at, somewhat related issue, is what happens upon the death of the homeowner. What rights do the heirs have? And there's a very specific section, 798.78. It's just a few sections further in from where we just were. That section allows the heirs to the home to, well, it gives them a couple of choices. An heir who wishes to inherit the home or inherit the tenancy, if they are an heir to the home, and get their own new tenancy, can apply under the same standards that I just mentioned to be approved. If no heir wants to live in the home, they have the right to sell it in place in the park. The only key to this is this: or the only condition is this, that the selling heirs have to satisfy all of the responsibilities of the deceased homeowner. That means that the rent has to be paid, utilities, the baseline utilities that are still going to come in have to be paid. The weeds have to be pulled, the lawn has to be mowed, the home still has to be kept nice while it's on the market. One area of real concern that comes up, and I've encountered this very recently and over the years, a couple of things. Number one, the estate says, we shouldn't leave this house totally unoccupied. It's not safe. Somebody could break in and steal stuff or damage the house. We don't want, we don't want vagrants coming into the home. We've heard the nightmare stories of how squatters can come into a home and how hard it is to get them out. Uncle Bob's not doing anything. Why don't we just move Uncle Bob into the house and he can watch the house and make sure there's a presence there? It makes perfect sense, right? For the estate to protect the home that way. Well, but here's the problem. Uncle Bob has no rights to be there as far as the park's concerned. He's not a tenant. He can't just move in and be a caretaker. The park's going to give a 5-day notice to the estate that says you have an unlawful occupant in the house. If they don't go within 5 days, we'll bring an action to get them out. And the result of that too is the park can take the position, aha, you're not following our rules by moving this person in with no authority. You are not satisfying the responsibilities of the deceased homeowner. Therefore, you just lost your right to sell the house in the park. I've seen that happen. You don't want that to happen. And one of the things that I think is being used by some park owners to kind of trick the estate beneficiaries or heirs is when the person dies and the heirs are talking to the manager and the manager says, oh, don't worry about anything. We understand this is a terrible situation. Please accept our condolences. We'll send you a bill and we'll figure all this out. And then a week goes by, then 2 weeks, then a month, then 2 months. And then suddenly when the estate is finally gotten itself kind of organized and maybe a probate's being filed, or now we've got the executor or a trustee that kind of knows what they're doing. And we've gotten past the memorial service and the burial and the bereavement. And then they go to the management and say, okay, we're ready to sell. And the management goes, oh, you lost your right to sell. You haven't been paying the rent. And they say, what do you mean we haven't been paying the rent? You told us just don't worry about it. Oh, I never said that. In other words, by this little lapse period, then they use it as an excuse to say, you can't sell the house in the park. And if they do allow it to be sold, then what they'll say is, well, if you let us raise the space rent, then you can sell. And in a rent-controlled jurisdiction, this is especially important because, as I think a lot of you know, the long-term lease exemption from rent control or rent stabilization is going away. As of January 1st of 2025, no long-term leases anywhere are going to be exempt from local regulation any longer. Park owners are going to be looking for other ways to decontrol spaces. They are. And this could be one. Somebody dies, they're going to try to trap the estate into a situation where they haven't been faithfully paying the bills or whatever, and then say, we're pulling the rug out from under you, you can't sell the home unless you negotiate something with us. So my advice to the estate is, as soon as somebody does pass away, communicate with the park in writing, make it clear that this is the person you need to send the rent bills to. We're ready to pay the rent because we're going to sell the house in place. And here's our intent to sell. And then we're going to give you notice about what upgrades you require under the section we talked about just a little bit ago. So you want to just be careful to stay on task and not get trapped in a situation where the park says you lost your rights. So those are the sections that I wanted to point out. Hopefully in doing so over the last half hour or so, I've answered some of the questions that we might be receiving. What I'd like to do now is go on to the pre-submitted questions that I've gotten over the past couple of weeks. Again, I think some of you on the call submitted these, so we'll be perhaps answering these to your satisfaction. And some of these would be questions I think that a lot of you would be interested in. And then we'll have plenty of time to take your questions as well. So let me just go through these as quick as I can. Question number 1. This has to do with the idea now that because of the bill that we passed last year, if the park owner rents out or subleases homes that it owns, it must allow the residents now to sublease as well. And these questions kind of go to that issue. If a homeowner rents out home, can he or she keep the $7,000 homeowner deduction that's allowed by the California Constitution, the tax exemption, if you will? The answer is no. If you rent out your home, if it's no longer your principal place of residence, you cannot claim the deduction or the exemption for that property. It has to transfer to wherever you are now living. Number 2, can the homeowner buy a second home in the park and rent it out? Well, the answer is yes, but only if the park allows that. And there are plenty of parks who do not allow an existing homeowner to buy a second home and rent it. And I think that's totally within their rights to have that in their rules or in their policies to say no. You know, if you live in the park, you have to live in the home and occupy the home we give you a tenancy for, but we're not going to let you become a landlord within the park. I know there are some parks who do allow it, but most parks in my experience do not allow an existing homeowner to buy a second home in the park and rent it out. The third part of the question was, can the park owner continue to buy homes and rent them out? Absolutely, they can. The bill we passed last year does not say they can't do it. It simply says if they do it, they have to allow you to do it also. What's good for the goose is good for the gander. Question 2. This is a question that has to do with cable TV billing. This particular park says that it's I guess the way they phrased it here is that it's mandatory for all homeowners that they have to pay for cable TV. If this is a resident-owned park, they could put together something like that as part of the assessment and say, because we all own the park, we're putting together our own rules and regulations and policies, and our policy is that everybody has to pay for this. But if this is an investor park, not resident-owned, I have to first say that there is a case that specifically says a park owner cannot make everybody pay for cable TV. And that's because it's not deemed to be an essential utility like gas, electric, water, sewer. Cable TV is optional. People can choose not to watch TV. They can choose to just stream stuff now on a computer or just watch DVDs or whatever they want to do. The case is called Greening versus Johnson. And that we have resources. We can provide anybody with a copy of the case or a citation if they need it. But you can look it up, Google Greening versus Johnson and read the case for yourself. And it makes it clear that the park cannot require everybody to pay for cable TV. The second part of the question was, how can we find out what the park is actually paying for the cable that they're passing through to us? Well, contact the cable provider. In this case, I think it's Spectrum. Ask them what the rates are, or demand from the park owner that they disclose that. The park has to disclose it. They can't hide the ball and say, I'm not going to tell you, how we figured out your cable charge. I mean, you're entitled to know that information, but watch out for a situation where they make you pay for something you're not using. Number 3, this talks about the 60-day notice of intent to sell that we discussed a little bit earlier today. And in this case, they're saying, we gave the intent to sell. The manager came out, took pictures of the house, but we have no word yet about upgrades or repairs. This is back in January. Now it's April. They're promising to give us upgrades lists, but we have nothing. What can we do? Remember what we just talked about, which is in 798.73.5, the upgrade section, they have 10 business days to give you those upgrades. one could argue that if they don't do that within 10 days, they've waived their right to require upgrades and they can't make you do them. But the key here is you have to request the upgrades list, the repair list. And I would say to this person, if your notice of intent to sell did not also say, please give us a list of upgrades pursuant to the mobile home residency law, they could argue, well, you never really made your request. And I know by inference, you could say, well, come on, a notice of intent to sell is basically a request, even if it doesn't specifically say it. But to really be clear, I would always say you need to specifically ask for the upgrades repairs list. And in this case, I would tell this person, if they haven't already done it, go back up the truck a little bit, now give them a written demand, and then that starts the 10 business days running within which they have to respond. Otherwise, 3 months is totally unreasonable. Number 4, we have a park. Actually, there's 2 parks involved in the Santa Barbara area where one of the park owner guys was a big pickleball fan and he wanted to build a pickleball court. So they did. They built this pickleball court and it was driving the residents crazy. The bong, bong, bong of the paddles and the balls for the people who live near was creating an incredible nuisance. And the residents actually, hired me to help them. They compiled huge amounts of evidence, and the local authorities shut the court down because it had been built without proper permits. And during the shutdown, the residents in both these parks really organized very well and presented a compelling case that the court should not be reopened. So thankfully, the park owner said, okay, we've heard you, we're not going to reopen the courts. But now what they're doing is they're turning the courts into apparently an employee parking lot. And the residents have concern that they're going to try to pass through the costs of building the parking lot to the residents. Can they do it? Well, that's going to depend upon a couple of things. Number one, what do the leases or rental agreements say about that? Do they allow pass-throughs for capital improvements? If so, we have to look at that language and say, is this a new improvement or is it repairing something that's pre-existing? If this is a brand new parking lot, the rental agreements may require a vote of the residents in order to approve the pass-through, that there would have to be a majority vote of residents to approve this brand new capital improvement. If there's a rent ordinance, the ordinance may have a very specific procedure about capital improvement pass-throughs that the park would have to follow. But the other thing I would note here is this: improvements in the park that do not benefit the residents should not be paid for by the residents. And if this is an employee parking lot, I would say, what benefit do the residents have from an employee parking lot? I would see none, actually. So I think that the residents in this particular park would have a really good case to not only investigate whether there's even a basis to do the pass-through, but also to say it's not the kind of capital expenditure that we should be responsible for because it does not benefit us, like roads or perimeter fence or a new clubhouse roof. Those kind of things benefit the residents. I don't think an employee parking lot does that. There was one question that we got specifically about, it's from Huntington Beach, but they're talking about rent caps and they're saying, what's the chance that we could pass rent stabilization for the entire state of California? And I just want to briefly say, that's not a policy that GSMOL has ever believed in. And I will never believe in it because really rent regulation is a local issue. It needs to be locally adopted by a county or a city. It needs to be tailored to the jurisdiction, the demographics. San Jose or Sunnyvale have completely different demographics than, Victorville or Visalia out in the valley. The income levels are different. The amount of rent increases that somebody could reasonably pay is different. So State regulation to me doesn't make sense, and it's also dangerous because once you give it over to the state, now you're at the whim of the state legislature and all the lobbying that happens at the state. Residents are far more likely to be protected by their local representatives, who they can go before as neighbors, right? Members of the community. Those local city council and supervisors are going to be far more responsive to the people that they live with than some state legislature that you've got somebody who represents, LA County voting on whether Humboldt County should have rent regulation. So that was a question I wanted to address, because state regulation is something that GSMOL, I think, will always resist. I understand that there's still some areas that don't have regulation, and that's something the Ed Fund wants to help with. And in Pico Rivera, for example, we just got regulation. The Ed Fund assisted with that project, and we're assisting in Santa Maria and Torrance, 2 other jurisdictions right now. But statewide, I don't think works. There was a question from Michelle about the situation where there's no regulation and the park owner or trade organization has these standard generic month-to-month agreements. And the question is there a threat if you got this month-to-month agreement that you could get a rent increase every 90 days? Well, the answer is yes. By law, if you don't have a longer term lease that says, every year, here's what the increase is, by law, every 90 days, you could get a rent increase. If you got rent stabilization, of course, you're protected. If you don't, then by law, it's possible that every 90 days, there could be another increase. But I would say that if a park owner actually did that, it would only be greasing the skids to get rent stabilization passed, because the residents would be flocking to the city council to say, look what's happening. These guys are raising our rent every 90 days. This is, absurd. And part of your question, Michelle, was, is this a rampant situation in California parks? And I would say, no, it's not rampant. I think just for the reason I just gave, park owners are sensitive to how this is going to look politically, but it could happen. It's not rampant, but it could happen. I've seen some situations where there's been more than one increase within 12 months, but very few. Even parks with no rent control or stabilization typically do one increase per year. Question number 7 is a really good question about hoarders. What if we have, as this question talks about, this lady who, God bless her, her carport's just full of stuff. There's tarps, all this unsightly stuff is piling up. She's got a car in the carport that's just full of stuff. The park says, oh, we're working on it, but nothing ever changes. What do we do? Do we have any rights as homeowners? Absolutely, you do. You have abilities to try to get the park to enforce their rules. Management may resist that because we don't want to have to enforce the rules. It's too difficult. It creates confrontation. We'd rather, not go there and just do our job, collect the rent, do the minimum, and then go home and watch TV and not have any controversy. But there are situations where management should and absolutely must enforce the rules. This is one of them because it creates a health and safety issue with hoarding like this. Management could evict, but they could also, short of eviction, get an injunction, which is far easier for them to get. And I've actually seen parks in hoarding situations do exactly that. They get an injunction first, and then if the hoarder does not comply with the injunction to stop this and clean it up, then they can go back and say, this person's violating the injunction, judge. Now we have no choice but to terminate them. And it's a 2-step process they can use. The other way to deal with this is get Department of Housing out there. HCD will come out and inspect a hoarding situation. They will call it a hazard, and they will cite the park owner and say, you got to make them clean this up. And if you don't, you could lose your permit to operate. Once they lose their permit to operate, they can't collect rent anymore. So that's a real threat. If the park doesn't enforce rules, residents could argue that's a breach of contract. They could argue that, my rental agreement with you says that these are the rules and you're going to enforce them and you're not doing that. one way to apply pressure is get a petition together. Submit the petition with as many signatures as possible to management saying, we need you to fix this and fix this situation. And if they don't do it, then you have, the possibility of even saying in a real extreme situation, we could file a lawsuit against you for not, enforcing the park rules. As part of that petition, say to the park, we're willing to help. If this poor lady needs help, we're willing to get some people out there to help her clean this up, because we feel sorry for her maybe too. Try to make it a community effort. Just going to open my blinds to get a little bit more light here. Question number 8 talks about water submetering. I'm just going to very quickly address this because this is kind of an unresolved issue. This particular management has told the residents that the new bill we got passed last year, AB 1061, which regulates how parks can charge for water. This park is saying we're already governed by the CPUC, so that bill does not apply to us. And I have to just say that this is going to be a developing issue, folks. We're aware that the park owner trade organizations have put out memos to their clients saying, we think that this bill doesn't apply if the Public Utilities Commission is already regulating in this way. I don't agree with that. I don't think a court's going to agree with that. And we may have to fight this one out. There may be a need to either strengthen and clarify the bill we got passed last year or to otherwise get some kind of opinion from the Public Utilities Commission. So I would just say stay tuned to that. If you have a park that's saying, we don't have to, we're not bound by that new bill, we can charge you more than $4.75 for administrative fees if we want, because we think that we're not governed by this bill, I would say complain to the Public Utilities Commission about that and let GSMOL know, because we may have to address that going forward. Okay, I want to try to finish these up if I can in the next few minutes so we can allow a full hour for your questions or more. We have a question coming out of Oceanside. Prospective buyers are being told they must sign a long-term lease in order to buy in the park. Is this legal? Actually, the answer is yes. The mobile home residency law does not protect new buyers in the sections that talk about leases and lease offerings. They only protect homeowners. You're not a homeowner until you've purchased a home and signed a rental agreement. So that's the catch-22, right? You have to sign the rental agreement to be a homeowner, and then it's too late to get out of it. This is a problem that we've faced for many years. There are court cases that clearly say purchasers are not homeowners yet. So the MRL doesn't literally apply. What you need to do is look in Oceanside at your ordinance. Does your ordinance have what's called a prospective buyer protection clause in it that says new buyers cannot be made to sign long-term leases that would evade rent control? There are a number of ordinances around the state that have that protection. If your ordinance doesn't have it, then they can probably require new buyers to sign long-term leases. But remember, as of January 1st of 2025, all those leases will no longer be exempt. Number 10 asked a question that I'm just going to answer this way. The question really is, there are some ramps in the park, like, handicap or wheelchair ramps. Somebody bought a home with a ramp, and then they're told, oh, the ramp's not up to code. Is this fair? Who makes the decision about codes and standards? Does the park have the priority to make that decision, or does the state? The answer is always the state, the Department of Housing. Title 25 is the body of regulations that is the building codes and standards for mobile home parks. We just call that Title 25. And they're very detailed. It's not the mobile home residency law, it's a whole separate code. And it talks about the very specific locations of homes on spaces and how steps and awnings are built, and roof loads and cabanas and storage sheds and all of that stuff, utilities. If there is a code issue, the park does not have the power to decide that. Either you get Department of Housing to come out and inspect, or in some areas, the local jurisdiction has become the local enforcement agency. The state has given control to the locals. So then you go to your local building planning department and you get their answer. But the park owner can never say, I don't care what Title 25 says, I'm going to tell you it's not up to code. No, I've encountered some park management over the years who think they enforce the state codes, but they don't. It's only the state. A quick question. When a park owner is processing purchase applications and they only use one credit bureau when they're submitting a request for a credit score, and the buyer thinks they could get a better score from the two other credit bureaus, what can they do? I would say go get credit reports from the other two. What is it? Equifax, TRW, and I can't remember the third one. If the park's only using one and the resident knows I got a better score than that from the other two, I'd say go get those printouts and give them to the park owner. And once the park owner has that information, I think they have a reasonable obligation to consider all of the credit scores. They can't just pick one. I think that's unreasonable to say it's only this one or nothing. There was a question about a kind of home called a park model. If some of you have ever heard of this, there are brand new homes that can be ordered and built off assembly lines and placed in parks. They're brand new, they look nice, but they're called park models. They're not actually mobile homes because they're too small to qualify. And the question is here, are park models mobile homes? And the answer is no. HCD had a written memo by a former, their former lead counsel years ago, who gave the written opinion that because the dimensions of a park model do not satisfy the requirements of the mobile home definitions in the codes, they are not considered mobile homes. However, remember this, any RV, any park model, any trailer, which is not by definition a mobile home, but is in its place and occupied by a resident for 9 or more consecutive months, if that's all true, that is treated exactly like a mobile home under the mobile home residency law for all purposes but one. So any kind of trailer, smaller structure can still be given all the protections under the MRL of a mobile home if it's been there for 9 or more consecutive months. The one exception is this: when the resident owner wants to sell that structure, the park can require that it be removed from the park. And that's a very specific exemption that's found at the very beginning of the mobile home residency law. It's actually in the definition of a mobile home, which is found at 798.3. So a very important distinction, because a lot of these parks are starting to get park models in now. Last couple questions. The question was from Bill: is a privately owned and managed mobile home park exempt from state and local water conservation mandates? I think I had told Bill that we want Bill to check on that locally, but my initial read would be no. I think water conservation mandates apply to all uses of water, unless somebody would show me otherwise. I would say yes, the park would have to follow any kind of conservation mandates. The last two questions, the one question was, I'm wondering when an older trailer and cabana are purchased in a mobile home park through DMV, how are property borders verified before closing the sale? I think what this question is saying is, we have an older structure, it might be a travel trailer or an RV, and it doesn't get titled by HCD, it's actually titled to the DMV, which all mobile homes used to be titled to the DMV until 1978, when Department of Housing began taking over their title and registration. But it doesn't really matter whether it's DMV or HCD. The question really is, when you're buying a home, how do you verify your property borders, what we call your lot lines? And those are verified by looking for evidence, physical evidence. At the front of the lot, it's typically a notch in the curb, in the concrete curb right out front by the front landscaping, the gutter curb. There's going to be some kind of mark typically. In the back of the lot, it's going to be some kind of physical thing in the ground, a pin, piece of rebar, a stake. Sometimes in the smaller parks, it's just, a tree or a fence post. But there has to be some physical evidence, according to Title 25, of lot markers. Also, a person could, if they really wanted to delve into it deeper, they could try to find a copy from either the state or the locals of the plot plan for the space. And the plot plan, which is signed off on when the space is constructed, is going to have the exact measurements of the space. And for most spaces in California, there is a plot plan still findable, but not always. So, lot markers are very important because you want to know where your lot lines are. As you may know, the park owner cannot move lot lines under Title 25 without the homeowner's consent and without getting a permit from HCD to do so. That's another whole area of a lot of problems where, management just comes out and starts moving lot lines. I've had a lot of cases like that. Last question has to do with swimming pool availability. And in this particular park, the park is saying that the pool will be seasonally available, essentially from Memorial Day to Labor Day. And if you want to use it any other time, you have to ask for specific permission, and you have to sign something that says you understand that if we let you use the pool in February on one day for some event, it doesn't mean that we're opening up the pool to everybody, all year round. So their question is, is this reasonable? And I would say, this is a close call for me. There are many parks that have seasonal pool rules. They don't have the pool open, because of the climate. And they don't want to heat the pool when it's 30 degrees outside. There are other parks that have them open year round. I think it really depends upon the climate where the park is located. It depends upon the demand for usage, how many residents live in the park, how many would use the pool during the entire year. And it also depends upon what the rental agreement or the rules say. I would look at those documents and say, do they say the pool is going to be open all year round? If so, then maybe it needs to be, or else it's a breach of contract. But it's not, in my experience, it's not abnormal for some parks to basically shut the pool down part of the year. It could be argued if, especially if the rental agreement requires that or says the pool is going to be open, it could be argued that if you close the pool, that amounts to what we call a service reduction. And that would entitle the resident to a rent rebate because of the loss of use of that amenity. We actually had that case we talked about last year out of the city of Hayward, where the park shut the pool down because of COVID and then never reopened it in the fall because of the fires and the smoke that was coming down into the San Francisco Bay Area. And the residents objected to that and then filed a service reduction claim under their local ordinance and were actually awarded money because the hearing officer found the park could have opened the pool earlier and they chose not to, probably because they didn't want to pay to maintain it. So the residents did get a minor amount of money, but the case stands much more for a valuable principle, I think, than the amount of money that they got. So probably something that needs to be looked at on a case-by-case basis. Thank you all for your attention. But just about an hour in, so I guess we're not doing too bad here. Those are all the questions that were submitted to me. Those are the issues I was asked to talk about. So Anne, why don't we all take a stretch?
And the first hand that we have up is Mary Lou Hensley. Go ahead, Mary Lou, take yourself off mute.
Hi there, Mary Lou.
Yeah, Bruce, I attended a meeting was it yesterday? God help me. Anyway, Matthew Weiss was there, HCD rep, on our Zoom call.
Mhm.
And he mentioned that I always thought the mobile residency laws, because it's a law, took precedent over any contract we may have signed here within the park. He was of a different mindset, because he said a lot of the issues that come before HCD are really civil code violations, and they don't get involved in that. All MRL and all HCD does is imminent issues
Well, I think
around your home and code.
I think I understand the question, and it's what you stated is not exactly true. But let me try to summarize, and then you tell me if you have a follow-up. HCD is the state agency which enforces what are called codes and standards. And codes and standards are found in the Mobile Home Parks Act, which is in the Health and Safety Code. The regulations that form the details of the Mobile Home Parks Act and the Health and Safety Code are in Title 25 of the Code of Regulations, what we just call Title 25. So HCD enforces codes and standards in Title 25. The Mobile Home Residency Law is a completely separate body of law. HCD does not enforce the MRL. My first question when I used to do all of our in-person road shows, as we called them, around the state where we did our MRL presentations, my first question to those in the room was, who enforces the Mobile Home Residency Law? The answer is, you do. There is no MRL police force. The Department of Housing does not enforce the Mobile Home Residency Law. The MRL protection program that we got put into place a couple of years ago, HCD has the apparatus, if you will, to receive those complaints, and they do a triage of them to determine which are the most egregious, but literally they don't enforce the MRL. That is a civil issue, and that's why we're on this call today, educating you all so that you know what your rights are. But if you need to enforce these rights, you might go to the district attorney, you might go to a city attorney. A lot of times you'd have to go to a private attorney, but HCD does not enforce any of the stuff we've been talking about today. You know, rental agreements and resale and inheritance, they have nothing to do with that. They enforce codes and standards, lot lines, sheds, cabanas, you know, awnings,
Right.
all of the technical building and codes issues. Rental agreements do not take precedence over state law. State law always governs, but there could be some things in rental agreements that HCD has nothing to do with regarding a homeowner's responsibility for things. Does that answer your question?
I'm glad you understood what I was trying to fumble out there, but it's very discouraging, because if you present the MRL to, as I have, management just glosses over it and continues doing what they're doing. To get it enforced requires deep pockets, of which most homeowners don't have.
Well, that's exactly,
So-
though, Mary Lou, why we passed the Mobile Home Residency Law Protection Program. That program, which HCD staffs, receives complaints, and if they are egregious, those homeowners who don't have deep pockets will have the complaint referred to a local legal provider who, for little or no charge, can then represent them. As well,
Okay.
that's why GSMOL exists, to be able to help you unify people in your park behind your rights, and many times without having to go to court, we can get things changed.
Thanks for that reminder. All right, thank you, Bruce.
You bet. Good question.
Okay, Martha, go ahead with the first chat.
First question is, what remedies are available to residents when the manager is abusive? For example, yelling at them in English when he is bilingual in Spanish and knows they don't speak English, and refusing to fill out their care paperwork to get the utility discount in a timely manner. He also tells residents he is, quote, too busy to deal with their issues. The park owner is aware and refuses to do anything. Most of the residents in the San Jose Park are very low income, non-English speakers, and many are undocumented. What can they do?
All right, so multiple questions, but they all kind of revolve around the same issue. Look, folks, I'll come back to one of the first things I mentioned today. This is an example of why we are trying to pass a bill that requires the licensing and training of park management. This is a perfect, glowing example of that. And the residents of this park should probably be contacted about supplying specific written narrative that we may be able to use before the legislature as we're getting this bill hopefully passed. We can't legislate morality. We can't legislate tone of voice, kindness, respect necessarily. You know, if a park owner is interested in somebody who's just going to manage the park and just treat everybody like garbage, well, to some degree, maybe there's nothing we can do about that. That's, in my opinion, a disastrously failed management policy, but literally that's really hard to govern. But we can govern some things. We can govern and prevent threats, the kind of abuse that results in financial injury. We can certainly prevent assault and battery or criminal activity. We can present taking advantage of people financially. When you have somebody, you know, yelling and hollering at somebody, maybe it's kind of hard to know how do we actually stop that, other than residents getting together and going to the park owner or to the upper management company and calling out this conduct. I've actually done that before, where I've sent the letter to the park that said, this is what your manager is doing. He's getting into verbal altercations. He's pointing his finger at people and touching them. Unwanted touching is a battery by definition, even just a touch. You could walk up to somebody and kiss them without their consent. That constitutes a battery. Assault goes even beyond that. If you're not otherwise, and what I've said to park lawyers or management companies in that situation is, I'm putting you on notice of this conduct. If you don't do anything about it and an injury happens, it's going to be on you, because I've made a record in my letter of this and made you aware. And now it's up to you to do something about it. And then if something happens in the future, that letter can serve as the basis for liability to the park owner if anybody's actually injured. When it comes to the care discount, that's a no-brainer, folks. The care discount, which is provided to low-income people, principally for lowering your gas bill, they have to provide that information. And if you qualify, they must, by law, give you the care discount. If they do not, then that person should contact the California Public Utilities Commission in San Francisco, the CPUC, and contact your serving utility, PG&E, Edison, Sempra, whoever that is. I get it, in a park like this, low income, a lot of non-English speaking people, that makes it harder, but we got to find a way to penetrate those parks to get somebody who's in the park who might be bilingual, who can help organize, or let them know, don't be afraid to exercise your rights. We know, I know, Martha, you know better than any of us on this call, the kind of mindset that people from Southeast Asia have, especially. They come from countries where if you object to things, you might disappear. They're not used to being able to actually speak their mind or be an objector, a public objector, and not have retaliation, sometimes extreme retaliation, visited back upon them. So I'm just kind of organically talking my way through this, but there's a lot of things in what you said. There are some things that can be remedied. Some things, unfortunately, just, kindness and respect, maybe we can't. But you'd want to try to do your best to convince the park owner to hire and keep employed people who are operating correctly and respectfully. Otherwise, it's a portent of bad things that could come from that kind of conduct. And if the park's put on notice, then the park could have liability in the future. Yeah,
Thank you, Bruce.
sure.
Okay, the next person with their hand up is Sharon Nielsen. Go ahead, Sharon.
Thank you. I wanted to touch on the effects of AB 861 and how it sort of interfaces with the MRL bit about subleasing 798.23.5C. Still trying to get clarification on this. You know, here at Flamingo Park, because of 861, now the management is approaching us with new rules about subleasing, and
I have them.
but pardon me, you
I have them in
them.
my hand.
That comes as no surprise to me, and I'm so glad that you do. And so, but you know, they're saying that you know, it's my understanding, and that might not reach far, is that that bit about the subleasing in the MRL was sort of this, you know, emergency measure to allow it, you know, for these special medical reasons when normally it wouldn't be. But I guess my take is that if subleasing is allowed, then that's sort of a moot point. So when it comes down to this part C about what we can sublease for, I understand that because it was being allowed under an emergency circumstance, there was this provision, you know, just to cover your expenses. But now if subleasing is just out there, like for all of us to do, you know, why wouldn't we be able to sublease for what we could get for it, you know, still adhering to whatever local thing.
I understand the question.
Okay, because they're still saying, well, you guys have to adhere to this one in MRL, but we don't, because we're not homeowners. Again, coming back down to that, you know, perverted definition in the MRL of homeowner. And
Okay.
so anyway, go ahead.
Yeah.
Thank
I'm
you.
not sure about a perverted definition of homeowner, but I think I can answer your question. And I actually had this out and I was prepared for your question.
Okay.
So let's revisit sort of the landscape of subleasing in the mobile home residency law. Originally, before AB 861 was passed last year, the provisions allowed only for limited subleasing, essentially for medical reasons that could not exceed 12 months. And the amount that the homeowner charged during that 12-month period could only be to defer the amount of rent or mortgage. In other words, they weren't allowed to make a profit off of the sublease. And then they were deemed to be, at the end of 12 months, they'd have to return to the home after this limited time away, and the sublease would end. What we did at AB 861 was to say, beyond the limited subleasing, if the park owner is allowed to directly rent its homes or sublease homes it owns, then it cannot prohibit subleasing. That's all that AB 861 says. It says they can't prohibit it. 861 did not presume to go into any details about the terms, rules, regulations, or policies surrounding the sublease. You see what I'm saying? So 861, which amended 798.23, doesn't talk about, well, if the park owner rents and the homeowners get to rent, what are the details around that? You know, how much can the homeowner rent for? And what kind of approval is required? That was all left open to the reasonable rules and regulations that the park owner would enact. In your particular case, in Flamingo, these new park rules and regulations dated this month that were provided to me, there's about 6 pages, as I recall here, a good 4.5 pages. In fact, what you say is true. Those rules are constructed based upon the old provisions, the existing provisions of the MRL. And they say you can only rent if we get an application from the subtenant, that we approve the application, we understand who these people are. They sign something saying that they agree to follow the rules and regulations of the park while they live there, that they are not going to pay you any more than what it takes to defer the rent amount, what you're paying to us, or adding in any mortgage or loan that has to be paid. In other words, you cannot make a profit off of them. And I get your question. Your question is, why shouldn't we be allowed like unfettered ability to sublease to anybody that we want for any amount that we want? Well, again, the focus of our bill was not to go that far. The focus of the bill was just to get around this prohibition. It's not really, it's never been in GSMOL's focus to say, we want to create a way for homeowners to make additional money off their homes, to create a profit center. That really wasn't our focus. Our focus was, it's not fair to residents who might need to sublease because they're getting a job transfer, or there's a health reason, or they got to go, leave the state for a while to see a sick relative or something. That was really our focus, to get rid of the blanket prohibition. This leaves open the park's ability to adopt reasonable rules and regulations regarding subtenants. And I think approvals, certainly reasonable, making sure they're going to follow the rules is reasonable. And in fact, because the MRL provisions, the existing provisions only limited it to, deferring the amount of outgoing expense, I would say right now that's also reasonable. So if we were going to address the issue you're raising, to say, we think residents should be allowed to rent for whatever they want and make a profit off of this, I think we'd probably have to go back into the bill and do more. Because I think it would be difficult for you to argue that the park owner adopting the same, financial constraints, if you will, that the existing MRL used to have, to argue that's unreasonable, that's going to be hard for you to do. So we just weren't really addressing the situation of wanting to enable existing homeowners to make a profit.
Okay, thank you, Bruce. Martha, go ahead with your next chat.
Yes, can Bruce please address the 7-day notice of rules violation? Management just sent more than 20 homeowners in a park 7-day notices of rules violations, but they didn't include the actual rules. The violations are all related to painting, awnings, railings, etc. And they are being given 7 days to make what amounts, in some cases, thousands of dollars in repairs. What are the homeowners' rights in this situation?
Good question. 7-day notices are referred to in the section of the MRL that governs the termination of tenancies. That section is 798.56. The subsection is D as in dog, which says that one of the 7 reasons upon which a tenancy can be terminated is if a rule or regulation of the park is not being followed, the resident has received a 7-day notice to comply with the rule and has not complied. If that happens, the next notice is a 60-day notice of termination. So when a 7-day notice is received, it's very important that the resident take that seriously and not just, throw it away or bury it under a pile someplace. You want to always respond to a 7-day notice. And there's basically 3 responses. First response could be, I admit that there's a violation and I will correct it. The second response could be, I deny that there's any violation and I'm not going to do anything because there is no violation. The middle kind of response would be, I can't tell from the notice what you're even saying. If the notice says, please trim your tree, and you've got 10 trees, well, which tree are we even talking about? In other words, I need you to be more specific. To be the most effective, a 7-day notice, the typical kind of 7-day notice that lawyers or the larger, more competent management companies create, they're going to very specifically spell out exactly what the rule is. They're going to actually recite the rule in the notice. And Rule 6 says this: you are in violation of Rule 6 because of the following. You're storing flammable materials on your space or under your home, or you're doing whatever the rule says about, you're annoying your neighbors, you're operating a business out of your home, whatever that might be. So when you get a rule violation notice, a 7-day notice, you want to really look at it and determine how you're going to respond. In a case like this, if the rules being, the violations being noted are items, repair items that could entail a significant cost, know this: the park owner understands that if they give a 7-day notice to someone to paint their whole house and they don't do it in 7 days, if they try to take that into eviction court, the judge or jury is not going to be sympathetic to that. They're going to say, this is totally unfair. You can't expect somebody to hire a painting contractor and paint their house within 7 days. But oftentimes these notices would say that, and they're not justified. The home doesn't need to be repainted. They're just piling on, trying to just leverage and bully and scare the homeowner into doing something they may have no obligation to do. So you always want to look at the notice and determine, is this even true? Does my paint look horrible? Do I have an obligation to repaint my entire house? If there is a legitimate issue and you get a 7-day notice and you can't afford it, you should always respond to the park owner and say, I'm willing to do it, but I can't afford it right now. I need to go find the money. I need to get a grant or help. I need to have somebody come help me do it. I had a client once too, they were trying to evict her because she didn't pull weeds in the middle of August when it was like 100 and something degrees, and she's a single woman with some health issues. She has to hire somebody. By the time she finds somebody, they can't get there within 7 days. So there's a lot of issues that come into play here that need to be addressed and sort of worked through. But while you want to take a 7-day notice very seriously, the thing to remember is it's not a 60-day termination notice. That's the next notice. This is the precursor notice. And many times, a park owner who's being properly advised by counsel, they'll tell them, don't try to evict somebody based on only one 7-day notice. What you want to do is create a paper trail. You want to give them multiple 7-day notices. Give them chance after chance after chance. And then you can go into court and say, Your Honor, we don't know what else to do. Carol just won't take care of this. We've given her 3 notices. She won't respond. She's not doing anything. We feel terrible. We'd rather not evict her, but we don't have a choice. That's the way they want to look, right, in court. They don't want to look like a predator who's just looking for an excuse to get somebody out. So I could say a lot more about 7-day notices, but I think given our time constraints here, that's kind of where I'll keep it.
Thank you. Okay, next is Dave T. Go ahead, Dave.
First, I was wondering if you can repeat the code numbers from the original, the sales in place that you first talked about.
Yeah, the 3 code sections, Dave, are 798.73, 798.73.5, and 798.74. 73, 73.5, and 74. Very important sections for y'all to know.
Okay, back to you,
Thank you
Martha.
very much.
You got it, Dave.
Yeah, this is a really interesting question. Regarding the pickleball court in Santa Barbara that was shut down by the county for noise abatement. The park residents paid for that improvement on a pass-through and now no longer have the benefit of using the court. Are the residents entitled to a credit or refund of the original pass-through cost?
That is an interesting question, and this is the same park I referred to in my pre-scripted questions with respect to the employee parking lot that apparently is now going to replace the abandoned pickleball court idea. I would say this will be a legal issue that would probably have to be taken to court. I would want to know, if I was going to be analyzing this as a lawyer, I would want to see any documents that pertain to the original pass-through. Building a pickleball court, if there is a rental agreement in place, is a new thing. The pickleball court in this case was built where it used to just be grass, as I understand it. It was part of a greenbelt little park area. So I would say that resident approval would have had to have been given if there were rental agreement provisions or local ordinance provisions that talked about that. If residents approved it and this court was built with no permits, such that it was then shut down and then deemed to be a noise nuisance, I would say the residents might have a very good case to get a rebate or a rent credit for the past amounts that they paid. I would also want to know what those amounts consisted of. I mean, if we're talking about $20, it's probably not worth pursuing. If we're talking about a pass-through that was in place for a number of months or even years that amounts to a lot more money, it could very well be worth pursuing. Residents could consider going to small claims court, although if a lot of residents are involved, it would be probably more effective to go to Superior Court and have a lawyer representing you to try to get that money back. It's a very interesting question. Again, I'd be looking at rental agreement language. I'd be looking at lease language. I'd be looking at the ordinance, looking at the basis for the pass-through itself. And then the residents may want to make a demand to the park owner. Maybe you could settle for an amount in the middle or something, or otherwise say, you know what, if you don't honor the demand, maybe we will take it to court and give it a whirl, see if we can get it back. Because you're right, if they paid for something that was only there for about 2 years, as I remember, and now it's going to be an employee parking lot, doesn't make a lot of sense. And that's part of the argument against the parking lot too. Why should we pay for a parking lot? We've already paid for pickleball courts that don't exist anymore. Now you want us to pay again for something that doesn't benefit us. Yeah, it's an interesting situation.
Okay, thank you, Bruce. Next is Mei-Ling Thomas. Go ahead, Mei-Ling.
Hi.
Hi,
Bruce.
Mei-Ling.
Hi, how are you? I
Good.
have a question. Our manager is not helpful for us. She hardly responds to our phone calls and she takes a long time to handle even little things. And our new residents moved in a month ago and they do not have the copy of any documents from the management. And we share the problem with our managed company and they want us to talk to the manager and they won't do anything for us. What should we do with this situation?
Yeah, boy, this is part of that whole management training issue that's been a theme today. Normally, I would say your first step is to do what you apparently have already done, which is contact upper management to let them know your employee is not doing their job.
Mhm.
If upper management is not responsive, then you'd have to resort to a different kind of remedy. But one of the things I'm wondering here is, when you contacted upper management, was it a group of homeowners making the contact, or maybe just one or two? Because if you
Just
have
one or two.
if you have a petition from a number of homeowners, if you have an HOA making the request, if you have a GSMOL chapter in the park making the request, it's going to have more clout. You know what I mean? Because it's not just, oh, that's just that crazy lady in the corner of the park. She complains about everything. And let's just, tell her to go talk to the manager and forget about it. I mean, you don't want to be dumped into that kind of category. You want this to be taken seriously. Especially, if document copies aren't being provided, that's a problem. Because obviously the residents are entitled to that. And there's actually a section of the residency law that says the right to rescind a document, the 72-hour right to rescind signature, doesn't apply till you get a copy of it. So somebody could argue the rescission rights are still ripe if they're not getting copies of documents. But I would say try petitioning and getting the voices of a lot of homeowners behind your requests and your complaints. And you also might want to trigger the meeting procedures in 798.53 that I was discussing in one of our current bills, the assembly bill that we have 2130 that's seeking to clarify and broaden that section. You can request currently a meeting with management about rules and regulations, park maintenance, or rental agreements. So request a meeting, get a local GSMOL rep to maybe be on the call as well, and or be on the meeting to help, guide you. Let management know there are going to be consequences if you do not properly supervise your employee. And we're not happy. And if you want a happy park, you should pay attention to this. That would be my initial kind of thought process. Ultimately, you could always have the remedy of the courts, but you should only resort to that if there's no other alternative.
Thank you very much.
Sure.
Okay, back to you, Martha.
Our roads were rebuilt in 2013. Cracks began to appear within 2 years. The HOA requested in writing to the managers to repair the cracks. That wasn't done. Now we have a bill of $140,000. This seems like negligence on the part of management. Do we have to pay for the repairs?
So it sounds like we're in a park that's either in a rent stabilization and RSO, as we call it, jurisdiction that allows capital improvement pass-throughs, or they live in a community with rental agreements or leases that allow capital improvement pass-throughs. Road repairs or resurfacing or replacement are a very typical kind of capital expenditure that is passed through. When you have this kind of situation where the residents believe, either because of what they saw with their own eyes during construction or what they're witnessing after the construction's completed, that the initial repair was not, shall we say, workmanlike. It was not up to industry standards. It was deficient. And therefore, now we've got these new cracks appearing. The issue is called deferred maintenance. The issue here is, why didn't the park do something to defer this huge maintenance bill by repairing those cracks or going back during prior years to take action that prevented maybe the catastrophic kind of failure that we're now all having to pay for? I would just say that if there's any chance to have any kind of administrative hearing about this, that's exactly what I'd be arguing. And I've actually been in cases where that's been argued, that, you could have greatly minimized the $140,000 cost if you would have just spent, $5,000 or $10,000 a couple of times over the years, maybe, to just do some resealing or crack or spot repairs. The useful life of roads should be longer than 9 years. I mean, if this was done, I guess it was done in 2010, so it's been 12 years ago. I would still say that the useful life of most roadways should be longer than 12 years. It should be more like 15 to 20 years. That would typically be the depreciating or amortization schedule for an improvement like that. But I'd also want to know things about, the climate. Is the park on solid ground? We have parks in the San Francisco Bay Area that are built right up next to the bay on fill. And when the garbage trucks come in and out of the park, those roads start breaking down because of the heavy weight of the vehicles. Those aren't going to last as long. So I think that would be part of the equation. But I agree that there could be a defense here of what I would call deferred maintenance. Yeah.
Thank you. Okay, next is PC. Go ahead.
Hi, my name is Maria Aguilar from Pico Rivera. My question is, what's the difference when you pay tax and property taxes? And the next question, does a depreciate value on the property because of the difference?
Okay, so PC, I'm gonna ask you to clarify. Let's talk about your first question. You're asking can you restate the first part of your question again?
What's the difference when you pay tax, and why does someone pay tax and the rest of us, we pay property taxes.
Okay, well, there are different kinds of taxes that a person is going to be liable for. Of course, we know about income tax, right? The money that you earn from your earnings when you file your tax returns every year, that's income tax that you have to pay. You also have to pay what's called local property tax. If you own real estate, if you own land, then you're going to pay real estate tax, if you will, local property tax on the land. When you own a mobile home, you have to pay either a registration fee to the state that's paid to Department of Housing, HCD, or you're on what's called the local property tax roll. We call that LPT. If you're on LPT, then you pay the county an annual fee. Typically for the average mobile home, that's going to be somewhere between maybe $75 and $150 or $60. But that's like your annual registration fee. So even though you don't own the land, you're just paying the tax on your structure, the personal property mobile home structure. So you're liable to pay that personal property tax to the county. It depends upon how your home is registered. And that's going to be showing on your mobile home title. Up in the corner, it's either going to say ILT or LPT. If it's LPT, it means you're on what's called local property tax. If it says ILT, it's called in lieu of tax, which means you pay a registration fee to HCD in Sacramento. Does that answer your question?
Yes.
Okay.
But does it have an effect on the value of the mobile home?
No.
Okay.
I mean, the taxable, the tax calculation that the county, if you're on LPT, that they calculate, that's based upon the taxable value of your home. But the taxable value is never, almost never the same as the market value of your home. You know, what somebody's willing to pay you for the home depends upon how nice it is, where it's located, the amount of space rent, and what other homes are selling for that are setting the market. That's not based upon the tax rate. The tax rate's based upon the county assessor looking at the value of your property. Do you have decks? How big is the house? How old is the house? And they're looking at Blue Book and National Automobile Dealer Association, we call that the NADA guide. They're looking at that stuff to come up with the tax. That's different from fair market value.
Okay. Thank you.
Sure.
Okay, thank you. Back to you, Martha.
What are the potential negative impacts for residents of a mobile home park when it is sold to a new owner?
Well, I would say that one concern that residents have is that the new owner does not have to honor the existing rental agreements, and that's false. If somebody has a 10-year lease with the selling park owner and it's got 5 years to go, the buyer has to assume that lease as part of the purchase. So that's one area that does not really have a lot of risk. Of course, the new park owner may have different operational goals or standards. So they might say, we're going to do a massive rewrite of the rules and regulations. We all know that there's a procedure in the MRL for that. In 798.23, they have to give a 6-month notice and have a meeting and go through all those procedures. But the biggest risk that I think I would find would be if you live, well, it really doesn't matter whether you have rent stabilization or not. When the arm's length sale happens and the new owner comes in, the local property tax that the park owner pays on the land is going to increase, sometimes by a lot. Because if under Proposition 13, property taxes only go up 2% a year on land until there's a change of ownership. When there's a change of ownership, the county can reassess the property to the current value. So if you had a park owner who built a park in 1960 and they've kept it for 60 years, and now they're selling it, you can bet the taxes are going to go up a whole bunch, because Prop 13 went into effect, if I recall, in 1979. So the tax base since 1979 is only going up 2% a year. And now there's a sale, and now they're going to reassess the taxes. The tax base could increase by tens of thousands of dollars. Well, who's going to pay for that? Rent control jurisdiction, the park owner will say, I'm going to have to file a petition for a fair return increase. And that petition might be based a lot upon the property tax going up. That's a really hard one to fight. When I've had those cases, that's probably the worst case scenario for me as the resident attorney, because it's hard to fight that. It's a tax, has to be paid. And other than just verifying the amount or trying to maybe negotiate some kind of amortization of it, it's really hard to defend or defeat those. So yeah, that's probably the biggest risk, is that a park that's been held for a very long time is now going to have this huge tax increase that increases their overhead. And therefore they're going to want to increase the rents to get reimbursed for that additional operational cost.
Okay, thank you. Julian Dean, go ahead.
In order to address issues like wanting to be refunded for the cost of paying for the pickleball court and not wanting to pay for deferred maintenance road repairs, do those kinds of attentions basically require that we hire private attorney?
There's a really good chance that it would, yeah, because those are major issues, right? It could be, I know that you have a lot of very eloquent residents that live in your park. I know that from experience, and you may be able to organize well and put together a very, well thought out, worded presentation that would compel management to understand and agree with you. But the likelihood is, when you start asking for a whole bunch of money back, or when you start asking for a pass-through to be discontinued, that may very well require legal representation. Yes.
Thank you.
Sure.
All right, back to you, Martha.
Lizanne has left the meeting, but I think her question is important, so I'm going to read it. If we have a long-term lease in effect on January 1st, 2025, what happens?
What happens is, beginning on January 1st, 2025, that agreement is no longer exempt from any local city or county rent stabilization ordinance. So if you live in one of the 110 or so local jurisdictions that have a mobile home RSO, as we call them, then beginning on that day, your space will now be subject to whatever regulations the RSO has, and the lease financial provisions will no longer govern. The lease will stay in effect. The other non-financial or non-rent provisions will still be enforceable. The lease doesn't just get blown up. However, the lease is now subject to the local law. So, for example, if the lease said that they could increase your rent 10% every year annually, now that annual increase would be subject to what the ordinance says, which might be, 75% of the CPI increase. But that's what happens as of January 1st, 2025. No rental agreement in California will be exempt from local rent regulations any longer.
Okay, thank you. All right, we have a telephone caller with a number beginning 619. Go ahead.
I don't know if I'm going to ask you the right question, but I'm going to give it a shot, because if you're not the right person, tell me. But my daughter, who's my executor on my estate, so I'm trying to get my paperwork together, and she has asked me about putting my three children on my for HUD, my title on the house, because I guess there's a pretty hefty death tax coming. And so I've got some questions because I live in this house and I'm paying for the homeowner insurance and my rent and all that. And I'm wondering if I do that, if that's going to affect, how that's going to affect me living here. Well, and then having them on my title.
Well, these are some pretty, you're getting into some pretty specific estate planning questions and advice. So I won't go too deeply, but I will just say this to you, 619. The death tax, or the estate tax, which is a federal issue under the Internal Revenue Code, does not affect most people because right now the exemption from inheritance tax is basically about $12 million if you're a married couple, and it's over $5 million for individuals. So the vast majority of us do not fall into that category. If you do and you are a multi-millionaire, I would say go get real specific tax advice from CPAs and very well qualified estate planning attorneys. But I would really take stock of what you're saying here, because if you have an estate that's worth less than $5 million, then you don't have any death or estate tax to worry about. And adding people to title is a problem because that makes them liable in case anything happens in connection with the mobile home. If you have a guest who comes into the home and falls through the floor and gets injured and sues you, they're going to sue everybody who's on title to the house. So putting your kids on title opens them up to liability. And if you don't have a tax situation to worry about, it's much better for you to stay on title, in my opinion, and create a will or a trust that gives them inheritance rights under the will or the trust. In my experience, the kind of folks who typically put their kids on title are folks who were not born here. They don't understand our laws. In my own experience, people from Asian countries seem to have the belief that if I don't put my children on title to a home while I'm living, they won't inherit it. And that's just not true. That's why we have wills and trusts. So I won't go any further than that because it's a little bit off subject, but I would say, take a closer look at that and get some local advice from an estate planning attorney or CPA before you make that choice.
Okay, back to you, Martha.
Star Management sent back our buyer's application to live here saying it was incomplete. Does the 15 days they have to approve it start when the buyer returns the updated application to them, or if not, when?
Correct. The 15 business days does not start until a complete application is received. And I understand there could be dispute about that, right? The park could just say, this is incomplete when it's really not. But if truly it was incomplete, and if truly the buyer needs to submit additional information, the 15 business days for the park to process the application does not start until the application is complete.
Okay, we have no more hands up. So Martha, if there are more chats, just go ahead.
Yes. Democratic Club, I sent you a message. If you're still here, Bruce might need clarification of this question. He's smarter than me, so maybe he knows what you mean. The question is, how do we as 400 plus homeowners get a higher credit amount for water? We've been newly submetered for the last 10 months at Rancho San Luis Rey Mobile Home Park in Oceanside. So how do 400 plus homeowners get a higher credit amount for water?
Man, I'm sorry, but I'm not sure I understand the question. When we're talking about a credit amount, I really don't know what that means. Obviously, the park should be subject to the law we got passed last year, which limits the park to recover the volumetric usage, the actual cubic centimeter feet that the resident's using. They can recover a proportional share of any fixed charge For example, if there's a $20 customer charge on the master meter, that's divided by the 400 spaces, and they can charge them a couple of cents. And then they can charge up to $4.75 as an administrative charge. But when we talk about credits, I don't really know what that means.
Hi,
Go ahead.
it's Victor Roy.
Hey, Victor.
Yes, and Bruce, we talked about this a while ago. So we were given a credit, 3 credits, trash, sewer, and water. And that was as we led into the sub-metering. So we got that credit, but
Can I stop you, Victor? When
Yeah.
you say credit, are you saying that this is the amount that under 798.41, when they start to sub-meter a category of utility, they then reduce your rents by the same amount? Is that what you mean by a credit?
yes,
Okay, now I'm
determined-
following you. Okay.
Yeah, they determined it was going to be around $70, and they broke it out in 3 categories.
Okay.
But many of us feel that as gardeners and what we have in our beautiful space, that they're not giving us a fair amount for the water portion. And you said, well, let's move into the submetering, and we can address this issue after the fact to see if we can get the credit raised. So how do we go about doing that at this point?
Yeah, sorry, when you were saying credit, I'm sorry, and maybe it's just because of the length of the call, but my brain was thinking you were
Yeah.
talking about some credit that was coming from the water provider. So I wasn't understanding the question.
Okay.
So under 798.41 of the MRL, that's where we are, right?
Right.
Which says that there are certain utilities that when they're bundled in the rent, the park owner can choose to unbundle them and begin to charge them as separate line items. But when they do that, they have to give you an equal reduction in your rent according to the amount that they're now breaking out separate. The way I always think of it is, if you're paying $500 a month in rent and $10 of it is allocated to water usage, then it's like we have 490 green dollar bills and 10 blue dollar bills. And once we take those blue dollar bills and we move them out separately, we only have 490 green ones left. And so that's the way it needs to work. Otherwise, we have a rent increase, right? If you're paying $500 and now you got to pay $10 for water, now you're paying $510. The idea behind this code section is, at the end of the day, you're still paying $500. It's just positioned differently in the bill. I just wanted to go through that to make sure everybody else on the call was understanding what we're talking about. So the question arises here, how did the park calculate the amount of water dollars, right? That's
Right.
really your question. And typically the way that happens is, the best way that can happen is the park installs water meters before they start the sub-metering. And they run those meters for a while without charging you, but just to determine what's the average usage. Because the code section says the average usage, the historical usage is how they calculate that. When they do what's called the simultaneous reduction in rent, when they break out the separate charge. If your question is, you believe that their calculation was not accurate, then I would say you need to assemble that evidence, because there is a problem in this section. When you literally look at the language, it gives the impression that each space could possibly have its own historical usage, and every space could be different. Some people have more landscaping than others. Some people use more water than others. And I know some homeowners have argued, well, they need to calculate every single space, and there could be different amounts all over the board. The park is always going to say, that's way too complicated. You can't put that burden on us. It's not fair to have some people getting more of a reduction than others. So what we're going to do is take an average. We're going to look at the whole water bill, divide by the number of spaces, track it for a number of months, and then come up with a number. So I'm assuming that that's what they at least say they did here. If you're going to challenge that, I'd say you need to come up with your evidence, right, to show otherwise.
Okay,
Okay,
Does that make sense? I mean, and when you say we think that it's too low, I would just say, okay, well, why do you think that? What is your basis for believing that? And is it more than just sort of anecdotal, right? In other words, no, we're looking at, they've actually started to submeter us now. And so we're looking at the amount of water that we're using. And we've got a representative number of spaces. And when we calculate that up, it looks like you haven't given us enough of a rent reduction here.
so the first course would be to challenge with a letter to the park management.
Yes, with
Okay.
with as much evidence, I would say that you have to do that.
Okay.
Yeah.
And my evidence would be, okay, you're giving each homeowner a $20 credit for water, but my bill shows that I'm paying $40 per month, not just 20 in the water breakout. So I'm challenging as an individual homeowner. What about, do I collect that from other homeowners and try to
Yes.
get, okay,
I'd get that from as many homeowners as you can, because again, the park's
okay,
going to say, we don't interpret this section as requiring us to calculate every space differently.
okay,
That's an unreasonable and overburdensome accounting requirement for
okay.
us. Yeah.
Okay, good. And of course, we know it's star management and we know what it's either going to be no response, a wall of silence, or they're just going to say verbally to us, yeah, no, we're not going to change it. And then,
So then
we
you're
got-
going to file an MRLPP complaint, or you're going
right,
to organize and file a small claims action or take them to court. Yeah, well, we know we're dealing with rats here, so
thank you, Bruce.
yeah.
okay, thanks.
I'll have to
All
pay
right.
royals to Shelley for that one.
Yeah.
Yeah.
All right, so phone number 619, go ahead.
Residents in my park received a rent increase notice in January, and at the same time, we were told our park was being sold. So far, the residents are being told the property is still in escrow. Is it typical to take so long for escrow to close on a park? And if the sale goes through, will residents need to sign new rental agreements? And what can we do to protect our rights?
So it sounds like three questions there. The first question is, how long does it typically take? I'm not sure that I'm qualified to answer that question because I'm not a real estate broker. But it could certainly take up to 3 months or longer if there are issues that need to be worked out. You know, when you're buying a large park especially, there's a lot of due diligence that needs to happen. You know, the buyer wants to get what are called estoppel certificates from all the residents saying they don't have any claims against the park owner because the buyer of the park doesn't want to be buying a lawsuit. They want to investigate utilities, infrastructure. They want to get all kinds of inspections. They want to make sure there's no pending citations by HCD. There could be financing problems. So I wouldn't say that, 90 days is ipso facto unreasonable. But I would think that pretty quickly something should be happening. Otherwise, I'm not really sure I can go further than that. The third question was, how do you protect your rights? Well, I mean, that's kind of a broad question, but really I would just say everything we've been talking about today really answers that question. Protecting your rights means knowing the mobile home residency law and holding the park owner to it. That's the best way I could sort of answer that. What was the second thing you said? I'm sorry, I forgot what the second part was.
Just that we were told there was a rent increase notice that we got supposedly from the new owner,
Right.
which was done improperly. The city of Escondido said it was an illegal rent increase. And
Yeah.
that was at the time that we were told the park was for sale. So that was just a statement. But this estoppel certificate, none of us have been giving anything like that. So can the park be sold without having that done?
Sure. Yeah, the buyer could just say, I don't need that. But if you're in Escondido, ma'am, clearly you're in an ordinance jurisdiction. And if the rent increase notice doesn't comply with state law, the 90-day requirement, or it doesn't comply with what the local ordinance requires, then it's not an enforceable notice. So if the city has
No, we
already,
know that.
Yeah, if the city has already said that, then I would say, you know, you're probably in pretty good shape that they can't collect the rent that notice presumes to allow them to do.
Correct. But I would, this estoppel certificate, I kind of stopped me when you mentioned that I know that we haven't been asked for anything. So everything that still proceed without that, that's one thing to know.
Yeah, that's the
But
buyer's election.
The buyer, okay. All right. All right. Well, thank you very much. I appreciate your information.
Yeah, sure. Good luck.
Okay, thanks. Back to you, Martha.
Okay, real fast, Elena, I answered your question in chat because we're getting close to when we're stopping, and your questions in chat. This is a rather long question, Bruce. Last month in March, our park experienced a power outage due to a blown transformer. The outage lasted approximately 36 hours. The first day of the outage, we did not receive notice or an update on the situation. The second day, we were notified through Facebook. Also, many residents expressing their discontent. Many residents contacted Edison, and they replied it was not their doing, and it was a maintenance issue with the park. The outage led to people's groceries, work days, and medication going bad. The management compensated with $100 on the next month's bill. My question is, what could be done on behalf of the residents that suffered severe losses? And I'm assuming she means more than the $100 of compensation.
Yeah, I mean, in those situations, residents need to make a claim. They need to state a claim in writing to management. You know, first of all, if they got $100, hopefully they didn't have to sign something that says, by accepting the $100, I waive all my other claims, because a smart park owner would have done that. You know, a smart park owner would say, hey, we're happy to give you this money, but we don't want you coming after us for even more. If they didn't do that, and the resident has not waived their rights to more money, then they could certainly make that claim. And if it's not honored, it's a small claims court matter. I've seen cases where groups of residents have all filed small claims court actions, and they'll have to prove their loss. You know, here's pictures of my refrigerator right after the power went out. You can see all the meat that I have in here, or here's receipts, or they would just have to prove their loss. But assuming that they don't have any individual losses of more than $13,000, which is the, I believe, the current small claims court jurisdictional limit, then that would be their ultimate remedy. But they should simply make a claim in writing for the additional loss. Yep.
Okay. Well, before we sign off, I would just like to make a couple of things. First of all,
Okay.
Thank you to Bruce. Thank you to Martha for her great help. And just to let you know, here are a couple of things that you can sign up for. To keep track of our legislative progress, go on to the GSMOL website, and there's a button there that you can sign up for our legislative email bulletins if you're a member of GSMOL. And the Ed Fund also has its own email list that we use to send out the announcements for these town halls. You can go on our website, which is edfundacademy.blogspot.com, and sign up for that email list. So I just wanted to give you those two sort of commercials. And thank you again for all being here. And our next town hall would be scheduled normally for July. So we'll find a time in July that works for Bruce, and we'll invite you back to our next one. And until then, be safe and be well. Thank you all.
Indeed. Thanks, everybody. Great to see you. Take care.